Happy 4th of July. Welcome to Health in Veritas. I'm Harlan Krumholz.
And I'm Howie Foreman. We're physicians and professors at Yale University, and we're trying to get closer to the truth about health and healthcare. Today we have Professor Tim Westmoreland of Georgetown University joining us. But first, we always want to check in on whatever's on your mind, Harlan. What's the hot topic of the day?
I know you're the one who told me what I should talk about today.
Oh my God, because I think it's the hot topic.
Your mind?
It's on everybody's mind.
Come on, what is it?
It is whether Biden's lapses during that debate are things that we should be concerned about, and whether we can explain it from a health
we are Health in Veritas, so we should be health and truth here.
Yeah.
And say it is this. I know that you wanted me to first start talking about the paper that actually an article that I wrote with Jeff Sonnenfeld, assisted by Stephen Tien, that was opining about what the cause of the problem was during the debate. I mean, look, 50 million Americans, I'm sure almost all of our listeners had a chance to either see the debate or view some clips of the debate. And, you know, the point that I had about Jeff in my discussions with Jeff, and let me just give Jeff credit. Jeff, was the one that said, could this have been a drug effect? And what I said to Jeff was, there was something that happened. And I think it's almost like a clinical event. Look, he had altered mental status, in my belief, during that debate. It wasn't just a slow start. It wasn't just a bad performance. It wasn't just like how Obama did against Romney.
And the facial expression.
Look, he couldn't string sentences together at the beginning of that debate. And then he said things that were just nonsense.
Right.
And, I had a professor one time in medical school, a neurologist, famous neurologist, who said to us, don't normalize your patients. And what he meant by that was sometimes people would come to you with very overt symptoms, and you'd sit there and go, well, I don't know. People sometimes slur their speech. Sometimes people drool. Sometimes people walk with a limp. Maybe it's normal. Your inclination is not to call it out as something abnormal, not to say that this is something pathological. Well, I mean, saw this and I said, this is different than what I've seen. You may debate whether or not he's lost a step or whether or not his cognitive function at baseline is different than it was a year ago. But this was different. I mean,
right.
When he started off and said we beat Medicare, which made no sense at all.
Still doesn't.
At the end of that, he was struggling and it was painful to watch. And so I said, when I see this as a clinician, I agree. The first thing that I think of is could it be a drug effect? And by the way, some of the common cold meds, especially things like Benadryl, can, have remarkable effects, dramatic effects on people's mental status, even temporally, because you had to also reconcile the fact that this was transient. By the time he got to Waffle House or North Carolina, it had lifted. He was in a very different space. Now, also, people with dementia, this can happen. I mean, there's lots of explanations. Small strokes can cause this. I mean, there are lots of things. I would tell you, if I saw somebody do that, I would think they needed to see a doctor.
Right.
I might send them to the emergency room because
right.
I would say something just happened and we need to figure out what it is. It could be metabolic. I don't know what it is. But, in the end, so we wrote this article that suggested, could this be meds? The White House didn't come out and say until yesterday that they said he wasn't on any meds, which also is kind of strange because he's got a cold. You mean you didn't give him anything for that? That seems odd. And then, so that theory is away, but the main thing was this seemed like an episode. And then Nancy Pelosi said essentially what we were saying, which was this seemed more like an episode than a general state. And so it requires some explanation. Now, he's come out now and said this is just jet lag. But, it is true. I thought it's a lot to put an 81 through 2 trips to Europe, a trip to California. Of course, he is on Air Force One, but, it's a lot of travel. But it was a week, he had a week of recovery.
Yeah, look, they need, I think Nancy Pelosi's phrase was best. Is this an episode or is it a condition? And if it's an episode, you still deserve some way to explain it. And it's not just travel that happened like 10 days earlier. So, look, I wish him well. I don't think that indicated that he can't carry out the job he's in right now. At least a single 90-minute period doesn't make me think that. But I am very concerned, and I think that we need transparency.
Look, if you were a pilot, would you be happy if he was flying your plane?
No.
I mean, this is the thing, and you and I have deep respect for him. We actually think this is one of the most remarkable presidencies with regard to accomplishments.
Correct.
You and I share that view. But, I saw the part of the press conference yesterday, too, and it's a lot of stonewalling. It's like, let's get back to his record. And it's not about that. It's about, and they said, look, don't make his presidency about 90 minutes. But if you saw something like that, if you see something, say something.
The way to make it not about 90 minutes is for them to be transparent and tell us everything that we need to know. And I really do sincerely hope that they clarify this in the very near future. And I personally, like you said, I wish him personally well. And I don't think that this necessarily means that he can't run or that he can't function extremely well the next 4.5 years. But this is a very important data point.
Yeah, I mean, and to make one more aside about this, of course, if you listen to former President Trump, he also didn't make sense during the debate.
No,
he
said we're used to it.
What was the thing about killing babies? I mean, I don't know what he was talking about. Like, that the argument that he was making that people somewhere in the United States are killing babies after they're born. But again, like, that is his baseline. I mean, that's baked in, right? I mean, that's not a change.
Right.
For Biden to be struggling to get out words and then to say things that didn't make any sense.
It was troubling.
Yep. Hey, so let's hope that gets clarified and we'll see what happens. I mean, look, we're living in dynamic times. But let's get on to Tim Westmoreland and talk about the consequential SCOTUS decisions and a little bit about Tim's background, which is quite interesting.
Timothy Westmoreland is Professor Emeritus of Law at Georgetown University, where he has been teaching about health law, health policy, bioethics, and importantly, statutory interpretation since 2001. He also serves as a senior scholar at the O'Neill Institute for National and Global Health. He kickstarted his career at the House of Representatives, working on healthcare policy matters for 15 years on the Subcommittee on Health and the Environment. He then worked for the Department of Health and Human Services in the Clinton administration as the director of the Medicaid program in the Healthcare Finance Administration, what we now know as the Center for Medicare and Medicaid Services. Professor Westmoreland also advised the Kaiser Foundation on AIDS and worked with the Koop-Kessler Advisory Committee as a consultant on tobacco policy. He has won many awards for his distinguished career in public service. He received the Robert Wood Johnson Foundation Investigator Award in Health Policy Research in 2002, and he was also selected to receive the Award of Courage from the American Foundation for AIDS Research, or AMFAR, that same year. He has also published many articles about public health and health law in national media outlets. He graduated from Duke with his bachelor's and received his law degree from Yale Law School. And so I want to start off because I think today we're going to spend a lot of time talking about statutory interpretation and specifically what the Supreme Court rulings are. But we would be remiss not to talk about your role working for Henry Waxman on AIDS policy from times when we did not even know AIDS existed, that you were elevating this to the nation's consciousness and being able to bring light during a time when the Reagan administration was not even noticing the disease. And if you could just comment how you got involved in that and how that transpired.
Well, first, thank you for the introduction and thank you for the invitation to be here. I had when I was working for the Waxman staff, I was the public health staff person. That was my portfolio, NIH, CDC, and FDA issues. And as part of that, I visited the Centers for Disease Control at the beginning of the Reagan administration and went around and met people in the various different program offices. And I met a guy whom I think both of you know named Jim Curran, who was at that point a CDC sexually transmitted infections investigator. He's now the dean, or maybe the retired dean, of the Emory School of Public Health. And he was working on, as part of this sexually transmitted infections, working on this outbreak of this form of pneumonia among gay men in Los Angeles, which was my chairman's district. And I said, if there's something that we can do to be helpful, I would like to be. I'm sure Mr. Waxman would want to be helpful. And Jim Curran said, no. The best I'm just barely getting the confidence of the gay community in Los Angeles. The last thing I need is to bring politicians and congresspeople into this discussion. So thanks, but no thanks. And then I said, well, let me know if it turns out there's something I can be doing. And about a year later, I got a call from him saying, I think I have their confidence now, and I think that we need to call some attention to this. And so we had a hearing in Los Angeles at the Gay and Lesbian Community Services Center and started that discussion and started with public health officials saying what they thought needed to be done, even though the Reagan budget officials were saying, no, we've got everything, we don't need anything more. And from that, I ended up doing about 35 hearings over the course of time on AIDS and HIV, and the Congress produced some legislation that arose from those hearings.
You know, Tim, that you've navigated the halls of power and have worked very closely with Ruth Katz, who we were privileged to have on the program recently.
She is my best friend.
We love Ruth, and I know you guys are so close. And you guys were such a formidable team in getting things done when you were working with Waxman. She reflects often on the changing culture of the Hill, the ways in which things have gotten more difficult. I just wonder, before we launch into, because we really want to hear your views on what's going on with SCOTUS, but I just wonder your own reflections on politics, where we are today, and whether there's any chance to reclaim the kind of spirit that you guys had and that your colleagues had to try to get things done. I mean, we do see things passed, but there's a very different feel, right, on the Hill now than there was then.
There is. During the time that I was describing just now to you, and when Ruth and I worked there together, I used to say that working on the Hill was like living in a dorm, that you went off to different classes during the day, but you would meet up and you'd be friendly. I actually went to the birthday parties for the children of the Republican staff. I went to a wedding of my Republican counterpart. We were friendly. We disagreed and we argued, but we were friendly. And these days, I went back to work on the Affordable Care Act during the Obama administration. I went back to the Hill, and it's scorched earth. People didn't even know each other's names. People wouldn't return each other's phone calls. And I find it very hard to imagine how the dorm-like atmosphere of being a staff person is going to return when people are as hostile and dismissive and downright abusive as they are to each other these days. To make the Congress work, people have to be able to sit in a room and come to compromise agreements. I used to sit down with my Republican counterpart and say, I can give on 1, 3, and 5 if you can give on 2, 4, and 6, and we can come to a compromise. These days, I don't think we could even agree on what was on the list. It's so harsh and so angry and so focused on sound bites. Whereas Mr. Waxman, at one point in a profile that was done on him, pointed out, and I think it's very true, it's amazing how much work you can get done in the Congress if you don't care who gets credit for it. And he was oftentimes behind the scenes or working to give a junior member, sometimes to the Republican Party, credit for getting something done. And consequently, we were able to come to some more agreements. I don't see anybody actually even giving people of their own party credit these days. And I certainly don't see that people are working collaboratively to be able to come to compromise and make important things happen.
You know, you really understand both the law as well as health law specifically. And we have had a very consequential Supreme Court term that ended just this week on July 1st. And I think suffice it to say that there are so many rulings that are non-healthcare that are consequential. But even in healthcare, there are big things. And we had Reshma Ramachandran on earlier this year to talk about what her thoughts about why Chevron mattered. But she spoke to it from a physician point of view and a public policy point of view. You have been teaching Chevron for decades now. Can you speak to why this concept, what did Chevron deference mean, and why does it matter?
Okay, let's do the very basics, and it'll only take me 2 minutes to do this, but I'll do the very basics. Congress writes statutes. often administrative agencies have to apply the statutes. And in doing so, the agencies oftentimes run into gaps and ambiguities about what the statute says. And agencies make a decision about what the best interpretation of that ambiguity is or how to fill the gap. And usually that's in the form of a regulation, although there can be other forms of interpretation too. And regulations have to go through a process. It's quite formal. And if someone is affected by an agency regulation and they disagree with the interpretation of the agency, they say that the statute says something else, they can challenge that in court. And they've been able to challenge it all along. So before 1984, a court would review the statute and review the arguments about how best to interpret it. And they'd consider all the arguments, including those from the agency, and the court would treat the agency's view as if it were an expert opinion, the view of someone who had a lot of experience in the area. But the court would said, and this was the Supreme Court doctrine at the time, that the court would make up its own mind about what the statute means among all the various possibilities. And the Supreme Court made that put that rule in place, which you're going to hear more of now, called Skidmore, in 1944. So it's been around for a long time. But 40 years later, the Supreme Court established a new decision of Chevron versus NRDC in a case involving air pollution. And they created two steps. The first step is for the court to decide whether the Congress's intention really was unclear. And if they say no, that we see what it means using the usual way of interpreting, then the court will enforce that no matter what the agency said. If the court says it's really ambiguous, we can't tell what the Congress's intent was, then the court would then look at what the agency's interpretation was. And unless the agency did something truly arbitrary or unreasonable, the court would defer to the agency. And that's what we're all talking about, Chevron deference.
Sorry to interrupt. NRDC, when you said Chevron versus NRDC, NRDC was whom or what?
National Resources Defense Council. It was an environmental case about the Clean Air Act.
Got it.
But the rule that came out of Chevron isn't limited to clean air or environmental. Right. It's been applied to anything having to do with agencies. But I want to emphasize that it didn't mean that the agency always won. The courts have said a number of times that the agency just got it wrong. It's step one, and they didn't even get to the question of whether to defer or not. But if they got to the level question two, we think it is unclear. Let's see what other interpretations. Most of the time, the agency would win if the court got to that level. And that Chevron rule has become a really big deal. It's a foundational piece of American law. I've seen it estimated that Chevron has been cited in federal court opinions 18,000 times. I've seen it estimated that Chevron was the turning point in more than 200 cases in the Supreme Court over the last 40 years. It's become the fulcrum of administrative law, from FDA to CMS to the Securities and Exchange Commission to the Defense Department. It's every place. And in addition to those arising in all those cases, I want to say it also has had a calming effect about litigation. A lot of cases aren't brought at all because lawyers know that the agency is likely to get deference. And so they go along with the regulation, and the courts don't have to deal with the question.
And just a quick follow-up to that, bringing it back to healthcare right now, public health law, CMS, CDC, FDA, what is the immediate implication for this?
For the Chevron decision? Or
for the reversal of it?
Okay. Well, Chevron is gone. Now we're back to Skidmore again. The court will decide. What it means for this is that in each instance, the court is going to make its own judgment, no matter how technical, no matter how obscure, no matter how unanticipated the question might have been. I used to tell my students that ask them what the Congress meant about the internet when they wrote the Telecom Act of, I think it was 1934. What did they mean? So now the court it's a power grab by the court to say, we're going to make up our mind. And so every one of these regulations and even administrative decisions, like drug approvals for FDA or fee schedules for CMS, every one of those is going to be somebody, when they make a decision, when an agency makes a decision, somebody's unhappy with it. Somebody thinks they should have been paid more. Somebody thinks the drug should have been approved, whatever. And now they can sue and say, well, the agency's interpretation was wrong. Let's take it to the court and show them. And, every single one of these actions is sort of up for grabs. The court says, well, if they're not happy with it, the Congress can write a new law. But the question, as we were just discussing, the Congress isn't doing very well these days. So almost, I think that the courts are going to be in charge. And even under Chevron, even with regular statutory interpretation, I've told my students over the years that this is Schrodinger's lawsuit. The meaning of the law is both alive and dead at the same time. The meaning of the law is A and B at the same time until a court says what it is. And it used to be, under Chevron, we could say, well, we've got a pretty good idea that it's going to be A because the agency said that. And it's just not good for, industry.
But here's what I'm trying to figure out, Tim, isn't this going to clog up the courts, one?
Oh,
two,
absolutely.
Does this mean, so just go back to FDA, because I've read what they've been writing about this, but I'm still, even as deep as I am in this, confused. And I know you explain things better than anyone I've seen comes to this kind of stuff.
You're very kind.
Well, so, the FDA, for example, is making, interpretations of statutory law all the time. Every single day they're making interpretations of it. So in the past, again, with this deference, people would say, well, the FDA is entitled to make that. They've got the expertise. Right. And now every time someone doesn't like something that the FDA says, they can basically now, with some prospect of being able to overturn, depending on the jurisdiction and the judge and the judge's biases, be able to actually dictate to what's going on. And here's my major point, I think, for everyone, not just, they say this is a triumph for, the conservatives, but, what business likes is predictability. They want to be able to know what they can rely on as they sort of making investments. And now it seems to me like they've just ratcheted up the unpredictability of the interpretation of statutory law. And like you said, the chance that Congress is going to get more specific on these laws is they can't agree on the broadest of things. Getting back to your first issue about how Congress gets together, they can't agree on the broadest swaths of thematic issues, let alone be able to get down where they're going to take the pencil and make this kind of highly specific issues. So I think this is going to create havoc, but am I wrong to be concerned?
No, you're right to be concerned. And, no clear law means confusion for everybody. And industry likes clear standards. They like weaker standards in many cases, but they like clear. And consumers don't like ambiguity either. They like clear information and protection from unnecessary. But now, in this instance, one of the things that I've seen people discussing this week has been that the statute for the Food and Drug Administration says that the agency is supposed to look at well-designed tests to decide whether something is safe and effective. But the definition of well-designed test isn't in the statute. The FDA has to decide what is a well-designed test. And in that instance, I suppose it means that somebody could show up and say, I have a drug here that I've studied in 4 people and nobody died. Approve it as safe and effective. That I did. I looked at them for 2 weeks, and that's a well-designed test. I would hope that any court would look at that even without Chevron and say, oh, don't be ridiculous. But you can't be sure. And it means, I mean, what you alluded to, each district court can have its own opinion of what's a well-designed test. And we could end up with,
But
50.
Isn't the court supposed to be considering feasibility, like what accrues as a result of their decision? I mean, that's what a puzzle about it.
Justice Jackson says in her dissent, this is going to create a tsunami of litigation. It's just going to be overwhelming. And it also means...
So this is like on the immunity case, they go, we don't want litigation. So that's why we're going to decide this. Here they're saying, oh, what the heck?
And, well, don't get me started on the immunity case. But what I cannot imagine is how many pieces of litigation there are going to be arising just because somebody doesn't like an individual decision made by an agency. And because of another case that came down, help me, Howie, Corner Post, is that what it is?
Corner Post, yep.
Corner Post, that decision said, over is not over. You can reopen things on agency regulation. So that means that they can go back and say, well, this test wasn't well designed, or that rate under Medicare was not fair, or this standard for 10b5 disclosure in the SEC isn't right. Harlan, it's not just for new things that everything is up for grabs. To some extent, the combination of those two cases means that for old things, everything's up for grabs. I mean, I know that a lot of conservatives have called for the end of the administrative state, but did they mean to get rid of it all at once? I mean, it just seems like it's going to be anarchy for a while. Anarchy for everyone who can afford a really good lawyer.
I want to make sure we get one last thing in before we have to go. Could you give us a little bit on mifepristone and whether the Supreme Court truly punted on that and what it might mean now that Chevron has been overturned?
Well, they dismissed the case for reasons that are altogether unrelated to the issue of abortion. They just said that the people who were bringing the litigation weren't harmed by the regulation, the approval of the drug, so they shouldn't be here. I mean, they even quote an old Scalia line, "What's it to you?" And these doctors shouldn't have been in court, so they just dismissed it. But it doesn't mean that somebody can't come back who, under the Chevron doctrine, or the reversal of Chevron, and now ask that the court revisit it because they might have standing to sue.
Right.
Or more important, even than that, is that a future administration can change the FDA approval of the drug for an altogether different reason and say, oops, we don't think that was a well-designed test, or oops, we think this is not effective. So we've got it coming from both directions, that an administration could change the approval, or another set of litigants who can say that they were harmed in some way can come into court and prove it. But in this case, it's a total punt. They didn't decide anything substantive.
So I just want to honestly say, like, you have been an amazing public servant, a professor, a policy advisor. You've come to Yale many times and contributed to our courses here. And most of all, you've been one of my best friends. And I just thank you for coming and joining us on the podcast.
Well, it was my pleasure.
Yeah, Tim, it's great having you. Thanks so much.
It was my pleasure. I'm happy to be here. Thanks for the invitation. And good to see you guys again. Enjoy the summer.
Howie, that was great. And, look, you've got great friends. Good friends with Tim. He's a remarkable individual, sort of an unsung hero, right? Because he's just contributed so much.
He is amazing.
Most people don't know his name, but he's done so much.
He has been an important person in my life, and I'm really glad we got to hear from him here.
That's great. So let's hear. What I said was, my preference now at the end of the program was to hear your views on some of these consequential decisions and their implications for health policy.
So I'm gonna run through them. Even though he talked about Chevron doctrine, I'm going to give you a very quick brief on that, and I'm going to cover each of what I think are the consequential rulings, but very briefly. And so I'm not a lawyer. I don't pretend to be a lawyer, but
but you're a health policy expert.
And I love the Supreme Court. This season, every year, I am very attentive to this. So I'll just remind our listeners what Chevron doctrine basically said is, if Congress has not directly addressed the question at the center of a dispute, a court was required to uphold the agency's interpretation. This is what Tim was getting at, of the statute, as long as it was reasonable. And
Can I ask you one question about this that I'm confused about?
Yeah.
A court needs to uphold it. Does that mean in response to someone filing something?
Yes.
Or
No,
so they don't automatically get involved.
But at a lower court, at a very low court, you could file something and they would say, look, Chevron doctrine dictates that you have not met this two-step test, and therefore we're throwing it out. It's not even going to court.
I see.
So that's how it starts each time, in my understanding of the law, right? And so now you have these sort of two rulings combined as one, Relentless versus Commerce and Roper versus Raimondo. And the court ruled 6-3 and 6-2. So a very split decision with the conservative justices in the majority and the liberal justices, so to speak, in the minority in the dissent, that Chevron doctrine is unworkable and therefore it's overturned. And going forward, the proper place for adjudicating legislative vagueness regarding regulations is back in the courts rather than in the hands of the regulatory experts. And we talked about what that may mean. And I will point our listeners to a paper by Sahil Agrawal, along with our own Reshma Ramachandran and Joe Ross in JAMA in March. We'll have it in the show notes. That really does a nice job explaining what this means for healthcare, and it means a lot. So that's number one. I think that is the most important thing in the term. Last week, we briefly covered Murthy versus Missouri. That was the free speech case, mostly rested on whether the federal government was encroaching on First Amendment rights of social media companies and their customers. And here, the court actually didn't rule on the substance, but felt that the plaintiffs did not have standing, meaning they had not shown that they were harmed by the action. So this is not quite a healthcare case, and it's not even really a free speech case. It's a standing case. And this nicely was Amy Coney Barrett writing for the majority. Alito, Thomas, and Gorsuch dissented, but that's punted. We haven't really made any free speech decisions here. That was on standing. The people who brought the case didn't really have a right to bring the case. The next case, which is what I asked him at briefly at the end, is FDA versus Alliance for Hippocratic Medicine case, which is the mifepristone case. And here again, the Supreme Court dismissed the case on standing, sending it back to the lower courts where it might continue, unlikely, but might continue. This was a unanimous decision, but on standing. Standing meaning that the people who brought the case didn't actually have a claim in front of the court. And with the reversal of the Chevron doctrine and the ruling in Corner Post, which extended the statute of limitation to file a claim of harm, this is going to come back to the court. And I do fear that in a Republican administration in particular, you will see this undone by executive action. And even without that, you may see it undone by court action. So mifepristone, which is 60% of all abortions, remains at risk. And then the other big case about abortion was Moyle versus the United States and Idaho versus the United States, which is where the federal rule called EMTALA, the Emergency Medical Treatment and Labor Act, which compels hospitals that receive Medicare dollars to provide emergency triage, stabilization, and disposition to acutely ill patients, including those in labor. that law comes into conflict with the Idaho law, which basically bans abortion completely, except to save the life of the mother. And the issue here was that the question is it only to save the life of the mother? What if the mother's life is not really in danger, but her fertility becomes in danger, or she's going to become septic or something else? And so here again, the court basically dismissed this case, in this case, on being improvidently granted, which is their way of saying that when they first considered the briefing documents that came to the court, they thought there was a case there. And then when they listened to the case, they realized there is no case there. So they didn't really rule on the case. They just said we shouldn't have listened to it to begin with. That too may come back. And then the last thing I want to mention is that we didn't talk about other sort of more marginal healthcare cases, but homelessness as a crime is another case that was ruled on, and additional monies for certain tribal nations for their health services were also ruled on. And we already know that in the next court session next year, we're going to learn more about transgender care in adolescents, and we're going to learn more about the limits of FDA authority for e-cigarettes and their distribution.
So there's a lot there. That was a wonderful summary. Let me just go back to one thing, because I just want to make sure I understand your point of view on this. So when I see something like the Chevron case, I think, so it was natural. People on the left were up in arms and people on the right, were cheering. Not uniformly, but,
right.
On average. But doesn't it matter who's in the executive office? Because, won't the Democrats be happy about this if Trump is elected? Because now, he will have less discretion. His federal agencies will have less discretion than they might have had otherwise. So the original who we're cheering for now, it's like it depends who's in office. Right.
So the original Chevron case was brought by Ann Gorsuch, the mother of the Supreme Court justice who ruled on it now, who actually I think wrote the opinion. And she was working for the EPA at the time, and they wanted to remove regulations. And the Chevron case came into play, give her the latitude to do that. And so I think you're right about it, but I think it also just puts the agencies into a position of almost paralysis. They have to hire more lawyers just to make sure that as they write regulations and as they work with Congress to write statute, it now has a higher bar to meet.
Yeah, it just seems a little unrealistic to me in the sense that if you do think that the agencies have some expertise, you're not really allowing them to express it as much. You've lowered the agility of the federal government.
That's right. And look, and that's the point that you were making at the beginning, is that right now the conservatives in government are not offended by paralyzing the bureaucracy because they actually see that as part of the mission. I don't mean all of them, but certainly some of them really believe paralyzing the bureaucracy is not a bad thing. And if this does that, not a bad thing.
Okay, but I can see that on an activist agenda. But, when you're talking about the FDA, there's a lot of these calls and...
Oh, my God.
These are balls and strikes that are being called here, and now they're going to potentially be each one thrown into question.
Absolutely. They could sue over the recent Duchenne muscular dystrophy drug approval. There's all sorts of things they could sue over that become much more difficult under these circumstances.
Great. Okay, well, thanks so much, Howie. That's amazing. You've been listening to Health in Veritas with Harlan Krumholtz and Howie Foreman.
So how did we do? To give us your feedback or to keep the conversation going, you can email us at health.veritas@yale.edu or follow us on LinkedIn, Threads, or Twitter. And I want to just add that this week is Independence Day, not only for the United States, but for the Yale School of Public Health, which as of July 1st is a fully independent school in Yale University, and Megan Ranney is the inaugural dean of that fully independent school. So kudos to them, congratulations, and happy Independence Day.
Oh my gosh, Howie, I'm so glad you reminded me about that. And just to make a big point, anyone who hasn't had a chance to listen to Megan Ranney, who we had on this program, is missing a treat, because she is vibrant, visionary. It brought a ton of energy. We've had good leaders before. I don't want to in any way diminish their contributions, but I'm thrilled to have her in the leadership role. And, And as an independent school public health, hey, everyone, keep your eyes on this school because things will be happening.
We agree.
So we want to hear your feedback, questions, experiences on our topics. Please do so. And also by rating us and reviewing us, helps more people find us. So just know we're eager to hear from you.
And we try to respond to your questions on whatever social media you put them on. So thank you for that. If you have questions about the MBA for Executives program at the Yale School of Management, reach out via email for more information or check out our website at som.yale.edu/EMBA.
Health in Veritas is produced with the Yale School of Management, the Yale School of the newly independent Yale School of Public Health. Thanks to our researchers, Ines Gil and Sophia Stump, and to our producer, Miranda Schaefer, recently married. She looks so happy. It's such a joyous...
We're really happy to have all of them. They are a great team.
Yeah. Talk to you soon, Howie.
Thanks very much, Harlan. Talk to you soon. Happy Independence Day to all listeners.